I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are on number 239 on our compilation list. We are going to be in 3 judges' courtrooms on today. Before I give you their names, don't forget to like, comment, share, and subscribe. Also, as you know, if you follow this channel, commentary will be added to these compilations if there were any when these proceedings previously aired. Also, chapters will be added for your convenience. Now, for our first judge, it will be my first time being in this courtroom. Shout out to Sovereign Citizen Chronicles for providing me with this proceeding. And that proceeding is coming out of the courtroom of Judge Daniel McDonald out of the state of Colorado. And I have a question for you guys. It seems like Colorado is becoming like Michigan when it comes to the sovereign citizens. I want you guys to let me know down in the comments, why do you think so? Second, we will be in the courtroom of Judge Regina Triplett out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Lisa Martin, also out of the state of Michigan. As always, it is a pleasure to bring you these compilations. And now let's jump in to 239.
Mr. Aaron Quiet.
Get you back here, Charlotte.
Aaron Quiet, 26 CR 840. Can you hear me?
Yeah, I have a request.
I can't really hear Mr. Quiet. Mr. Quiet, can you hear me?
Yeah, I have a request.
I can't really hear him.
Hey, Mr. Quiet, you gotta speak right into the door. Not right now.
Mr. Quiet, can you try to speak a little bit more through that door so to get into that speaker the deputy's holding?
I have a request.
He keeps stating that he has a request, Your Honor.
Well, if you have a request, I'd be happy to hear it. But if you say it where you're at, I can't hear you.
I have a request.
Oh, I can hear you now. Okay. Let me tell you something really quickly, and then we'll talk about your request, okay? So in this case, it's 26 CR 840. Mr. Quiet appears in custody at the jail. It is a first appearance. Bond has been set at $3,500 cash or surety. You were advised of the complaint when you were down in courtroom 1A. You have 1 class 6 felony assault in the 3rd degree against an at-risk person. Mr. Quiet, would you like the court to appoint the public defender today?
No, I have a request.
All right. So you do not want a public defender, is that correct?
Correct.
All right. What's your request?
Now on, can you refer to me as Aaron and not my full name unless you have to?
Can I refer to you as Aaron?
Yeah,
Why?
privacy.
I can't hear you.
Privacy.
All right. Go ahead.
I'd like to petition the court for a reduction or dismissal of my bail. I believe the bail that was set in this case for the offense that allegedly occurred on June 10th was excessive and in violation of the 8th Amendment of the United States Constitution and Section 20, Article 2 of the Constitution of the State of Colorado. As held in People v. Jones, if bail is set in an excessive amount, the defendant has the right to petition for a reduction of bail or appeal the bail decision. In determining whether or not bail was set in an excessive amount, the court should look to the purpose of setting bail. Lucero v. District Court and LOW.
Hey, Mr. Quiet, let me just cut you off right now. This is a victim's rights amendment case. The court cannot legally address your bond today. We can set it for a bond review, but I can't review it today.
Lucero v. District Court and LOW v. District Court held that the purpose of bail is to ensure the defendant's presence at the time.
Right, I'm aware of the case law, but I can't address your bond today, Mr. Quiet. You're wasting your time. So I can set it for a bond review if you'd like.
Yeah.
All right, what's your next request?
In accordance with Colorado Rules of Criminal Procedure Rule 5, I would like to request a preliminary hearing. Further, to satisfy Colorado Revised Statute 186105, I believe the court should set the date for the as soon as possible. That section states that, quote, consistent with the constitutional right to a speedy trial, all cases involving the commission of a crime against an average person must take precedence before the court, and the court shall hear these cases as soon as possible after.
Yeah, you have a right to a preliminary hearing. If you're requesting one, I'll get it set. Is that what you're requesting?
Yeah, and further, to satisfy Colorado Revised Statute 186.5, I believe the court should set a preliminary hearing as soon as possible.
All right, let me ask you some questions, okay? We need to talk about your waiver of an attorney. All right, you understand you have a right to have an attorney?
Yeah,
You understand you have a right to represent yourself?
yeah.
All right, the court has to engage in a process where I have to use extreme caution in obtaining a waiver of counsel. I have to indulge every reasonable presumption against finding a waiver of counsel. And again, I have to I have to assess your background and experience, conduct, and history of any mental illness in determining whether there's a waiver that is voluntary, knowing, and intelligent. So do you understand that you have the right to be represented by counsel throughout these proceedings?
Before I answer that, I have another request.
No, you're going to answer this question right now. Do you understand that you have the right to be represented by counsel throughout these proceedings?
Before I answer that, I have another request.
I can't find a waiver. I'm going to appoint the public defender. The public defender will be appointed in this case. Mr. Quiet does qualify given he is in custody. He has requested a preliminary hearing within 35 days.
I will represent myself.
You won't answer my question, so I can't make the requisite findings.
I'll answer your questions.
It's not a game, Mr. Quiet. I gave you your opportunity.
The police deliberately prevented me from appearing in court today to stop me from delivering this statement.
All right, I've muted Mr. Quiet. I'm going to set a preliminary hearing. Are the people available for a preliminary hearing on July 15th at 4:30? Actually, you know what? Let's set it at 4.
Is the court appointing me or not?
Yes.
July 15th at 4?
Yes.
People are available.
All right.
I could do that.
I can't find under Arguello a knowing and voluntary waiver because he won't answer the questions I'm asking him. So the court will appoint the public defender. We'll set the preliminary hearing July 15th at 4. That is when I will see Mr. Quiet. That is the soonest possible date the court has for that preliminary hearing. All right, who do I have on station 8?
That is
In the matter of petitioner Charles Paul Nurswick versus respondent Lindsay Ann Dineski. Ms. Dineski, please state your name for the record.
Lindsay Dineski.
Please raise your right hand. You solemnly swear or affirm any testimony you provide to the court today will be the truth and nothing but the truth.
I always tell the truth.
Dineski, we had a bench warrant to issue for your arrest back in December 4th, 2003.
There was no proper service on that. I was never given any service on that warrant, so it's invalid.
So the warrant issued because you failed to appear
For a court that I never received any service on.
for the show cause hearing. I do see that proof of service.
I was in another state, so there's no way I received any proof of service, and you guys had my email and my phone number, and nobody ever contacted me, so this needs to be thrown out immediately.
So that's not how the court.
Yes, it's what the law says. The law says if I do not have proper service, it's an invalid warrant.
Okay, Miss.
Demand a trial on this matter because I've never been able to present any evidence.
Be quiet.
This is my hearing and I'm allowed to speak at my own hearing.
I have to let you know I'm arraigning you.
You're reading it on an invalid warrant. This needs to be dropped immediately. Is this an Article 1 court or an Article 3 court? Because if this is not an Article 3 court, you have no right to adjudicate anything to do with my liberty interests. And my children are my liberty interest, and they are my offspring. And this man attacked me, so this entire PPO is based on fraud and is void. So that not only can you not arraign me, but you need to overturn the PPO immediately.
So, Ms. Dineski, you were served on October 23rd, 2023. There was a show cause hearing for a violation of the PPO that occurred on December 4th, 2023. Just for the record, I have muted Ms. Dineski because she refused to be quiet.
You're not allowed to mute me at my hearing. Is this an Article 3 court or an Article 1 court, ma'am? You have to answer me. Are you an Article 1 judge? Because if you are, President Trump said that you are not allowed to hear anything to do with my liberty interest in his executive order that he recently put out.
All right.
Are you Article?
Is that you stopped Mr. Nurswick's mail? You were interfering with his mail, Ms. Nurswick, and wasn't able to receive his mail.
If you do not have a constitutional oath, then you have to recuse yourself immediately and let me have an Article 3 judge, because this has to do with my constitutional rights. And Article 1 judges.
So the court is in receipt of a customer information form that
You do
appears
not consent to this PPO, and you must prove and show your oath.
USPS at an address of 18337 Ewell Road, Belleville, Michigan.
I was not living there. I had been evicted from there previously in June, so there was no proper service.
The petitioner filed a motion complaining that you, Ms. Dineski, stopped his mail.
I didn't stop anybody's mail. He came and stole my mail and signed for a certified letter that he sent me, so I didn't receive it. And you guys won't let me show evidence. This has been going on for over a year, and I've never once been able to show evidence, and I've demanded a trial multiple times, and you've denied me a trial. So you're going to be going to prison under USC 18, 241 and 242, and I'm going to be asking for the death penalty for you.
Well, guys, as you can see, Ms. Dineski definitely has her sovereign citizen head on, her wild head on. She's telling the judge, listen, if you're an Article 1 judge and not an Article 3 judge, we heard her, Trump is not allowing you to basically hear my liberty interests and so on and so forth. And to me, she really went over the edge, and the Judge Triplett, just pretty much ignored it, didn't really entertain it. But for her to say, and I guess obviously she didn't entertain it because it was nothing to entertain. It wasn't a real thing that could happen. But the fact that she told her that she was going to be pressing charges and, having her going to jail and then seeking the death penalty, I mean, that was just super insane for her to say, especially knowing that that's something that can't possibly happen, which may show us that something is definitely going on in Ms. Dineski's head. But nonetheless, let's jump back into this proceeding.
Stand by.
Yeah, stand by. This is also a bill of payment and penalties, which has been outlawed by the Constitution, Article 1, Section 9, Clause 3. You are using an unlawful PPO to withhold me from my offspring, which qualifies as kidnapping and hostage taking and treason and torture. This matter is void ab initio from the beginning because it's based on fraud, and fraud vitiates everything. Marbury versus Madison, anything repugnant to the Constitution is void. This is a violation of my free speech. This is a violation of my right to petition the government for redress of grievances. It's a violation of my Second Amendment because you said I couldn't have a weapon or bear arms.
Ms. Dineski, I'm going to put you in the breakout room with Ms.
This is a violation of my Sixth Amendment. This is a violation of my Sixth Amendment. This is a violation of my Seventh Amendment. This is a violation of my Eighth Amendment right, my inalienable Eighth Amendment right. This is a violation of my Ninth and Tenth Amendment rights. You are violating all of my rights, and I have not ever been allowed to be heard. Due process allows me the right to be heard, and this has been ongoing since 2023, and I have never had the right to be heard. And I've had my babies unlawfully held from me based on fraud, which I never got to present evidence to prove otherwise.
Okay, we don't have a prosecutor. I'm putting this over. I want to reconvene at 2:00.
I'm demanding a quo warranto.
All right.
And I need
Deputy, did you hear me? Officer?
Your Honor, I do have a 2:00. Did you want me to come back? I have a 2:00 in
I don't need an attorney. I don't consent to an
Yeah,
attorney.
I can't. I don't have a prosecutor. I need you to come back. What about 2:30?
I want to say something. You guys are.
Miss Williams,
Your Honor, I'm talking to
5 days.
I
I've been
have
here for
no
5 days.
prosecutor.
I was
I
not
got
even notified of this court. I was not even given notice of this court date, and I've been here. For
So
5 days.
Mr. Ness,
let's
please
say
be quiet.
1:45. I don't have a prosecutor.
You need to be
I can't
quiet.
do
This
anything.
is my hearing.
Can we do 1:45, officer?
Yeah, 1:45.
Okay,
All right, we'll
I'll be
see y'all
back at
back at
1:45.
1:45.
Okay, thank you, Your Honor.
I do have one question.
Go ahead, officer.
Just for staffing purposes, can you give a time, because that's right around shift change, do you think that hearing would be done by 2:30, or are
I'm
we
waiting
looking
on a
at
prosecutor.
2:30?
I can't.
Well, it has
The
to,
record is
Your Honor,
going
I have
now.
a 2:00.
I can't call
I
it.
don't
So
need a prosecutor. I'm asking for this to be
Okay.
dropped.
yeah, 1:45 is the time that I have.
I want
Okay.
you to answer any of my questions.
Your Honor, I'll see you at 1:45. Thank
Sounds
you.
good.
You just ignore my questions.
I do believe arraignments can take place without the prosecutor's office, but
I kind of thought so. I
Must be-
did start, but for this particular one,
Yeah, this one, I think.
considering the fact that,
yeah,
I've been, this is, we needed you here. That's why I started off and I was like, oh no, let me.
Leslie, as far as the allegations go, I do believe that this is a bench-borne arraignment.
Hold on.
Oh.
Yep, it is. Let me start to call the case. All right, CJC, are you there? I want to call the case, but I want to hear from you.
Yes.
All right. All right. Thank you. Let me call the case.
Recording in
This
progress.
is case number 23-104850-PP in the matter of Charles Nurswick versus Lindsay Ann Dineski. Mr. Tudge, if I could get your appearance for the prosecutor's office.
Good afternoon, Your Honor. Gregory Tudge, P85961 for the people.
All right. Ms. Fort Williams, your appearance, please.
Good afternoon, Your Honor. Gail Fort Williams, P35963, counsel on behalf of
All right, Ms. Fort Williams, you had an opportunity to speak with Mr. Dineski in the breakout room.
Why is there still an attorney on my case when I said I don't want one?
I attempted to speak with her, Your Honor.
I do not want or need an attorney.
All right, Ms. Fort Williams, I just want you to stand by at this time, if you can do that.
And I'm entitled to relief from judgment under Michigan Court Rule 2.612 because I was not personally notified of this matter. And so it needs to be dismissed immediately.
Ms. Dineski, you were arrested for a warrant issue because of your failure to appear.
A failure to appear on something I was not personally notified on. So under Court Rule 2.6123, not personally notified, I am entitled to relief from this proceeding and action.
Okay, let me hear from Mr. Tudge. Go ahead, Mr. Tudge.
Your Honor, it does appear that the 2.512, I believe, was the citation, which 2.516.
I'm sorry, 2.612.
Chapter 2 of the Michigan Court Rules governs the civil procedures. This being a quasi-criminal matter,
This is a civil procedure because it's family court.
Hold on, Ms. Dineski, let Mr. Tudge speak.
It's not quasi-criminal, this is civil.
All right.
So that's a twisting. This is a family court matter.
Ms. Dineski, please let Mr. Tudge speak first, please. Go ahead, Mr. Tudge.
I thought this was my hearing. I should be the one speaking.
Mr. Tudge is from the prosecutor's office.
He doesn't need to be on this case because it's civil. Prosecution doesn't happen on civil cases.
Go ahead, Mr. Tudge.
Thank you, Your Honor. The MCR 2.612 does appear to be governing civil proceedings. This matter being a quasi-criminal proceeding does and is controlled by the court rules which address misdemeanor offenses unless otherwise stated in Chapter 3 under special proceedings. I do believe that the cited rule is inapplicable for this proceeding.
You may proceed.
I'm sorry, I didn't hear him. Did he say applicable or inapplicable?
It is applicable, Mr.
Oh, okay.
Okay, go ahead.
Your Honor, I must correct the court. The argument is not applicable, inapplicable.
Oh, he said not applicable.
Why would it be inapplicable?
Your court rule. He's saying the court rule your side, his position, and I agree with him. Let me just say that for the record, that the court rule your side, it governs civil procedure. It doesn't govern under quasi-criminal matters.
This is not a criminal matter. This is a civil matter. It's a domestic matter. How is that criminal?
Ms. Dineski.
And in criminal procedure, it's the same thing. These also, the criminal code also.
Dineski,
the reason why I looked up the.
I'll give you an opportunity to speak, but I need to hear from Mr. Tudge first.
But it's my hearing. I should be heard first.
No.
This is my hearing. I'm the one who's supposed to be heard, not the prosecutor.
But they're being heard because you're violated a PPO.
I didn't violate anything. I was not notified.
Sorry, the allegation that you violated a PPO.
Okay, well then I have a right to say was not notified.
I'm going to give you that opportunity, but you have to. The allegation is that you violated a PPO. You have to let the prosecutor's office, the representative of the attorney from the prosecutor's office, speak. Go ahead, Mr. Tudge.
Your Honor, I don't believe I have anything further as to the argument as it relates. I would ask that the arraignment for the bench warrant continue, and I would also ask that the court inform the respondent of the standards for which respondent will be held if proceeding pro se, and I believe it would be appropriate.
I'm proceeding sui juris and persona.
Well, I am going to ask Ms. Fort Williams to operate.
No, I don't want an attorney. I do not attorney.
Ms. Dineski, I have acknowledged the fact that you are not wanting an attorney.
No, I refuse it. It's not that I don't want one.
I have Ms. Fort Williams to stand by. She's just going to stand by.
Even though I
what else would
appreciate
you like to say, Mr. Tudge?
I believe it may be of benefit for the court to voir dire or Attorney Williams to voir dire respondent as to a right to have counsel and whether respondent knowingly, intelligently, and voluntarily waives the right to counsel.
All right, Ms. Dineski, you understand? Go ahead, Ms. Fort Williams.
Your Honor, I just wanted to say Ms. Dineski was speaking about being served with the violation, and she's indicating that she was not served. She may have been quoting the incorrect court rule. I don't know. I don't have the court rules in front of me. It doesn't matter, though. Either way, of course, anybody in court has to be served with the appropriate papers. What she is indicating is that she was not served. And I indicated to her, but I don't think she was listening to me because she was talking and I couldn't talk. I indicated to her that this is an arraignment and that she will have the opportunity to address service or lack thereof, if that is the case, when a trial is set or whatever is set.
No, according to versus McVicker, I can challenge us at any time.
Ms. Dineski, you have to be quiet. For purposes of what she was indicating, Your Honor, it is true that everyone has to be served. I don't know about that court rule, and it doesn't matter whether she's quoting all these rules. It doesn't matter. She's indicating she wasn't served. That's all.
Now, you know that you are aggravating the courtroom when your own attorney gets so frustrated that she tells you to just straight up be quiet. Now, we've seen a lot of sovereign citizen proceedings here on the channel, and we've seen different sovereign citizens go in on their attorneys, so on and so forth. But I've never seen any attorney tell their client to be quiet, even if it's a sovereign citizen, even if they don't like what they're saying and they're not listening. But this lady is totally frustrated. She's had it with Ms. Dineski, and Ms. Dineski just keeps going on and on and on.
Thank you.
Thank you. But the thing is that it doesn't matter if this
Hold
is
on, Miss. Procedurally, there are things we have to do, Mr.
No, not if my rights are violated. Procedure does not have my rights.
Mr. Tudge, do you have a response to that?
Your Honor, it's indicated, I believe in the court record, a proof of service has been submitted. If there are further questions as it relates to service, and ultimately it may be, however, I leave this to either respondent, or if respondent wishes for an attorney, respondent's attorney to address that if there is a request or a motion to have the court issue a summary judgment as to the alleged violation, the burden of proof would be on respondents to do so.
All right.
It would not be. The burden of proof is on the one who would process the service. I was out of state when this hearing was set up.
I do show that a proof of service was filed for notice of hearing for the show cause that took place on December 4th, 2024 by the attorney that was representing Mr. Nurswick.
So where did he serve it to? Because I wasn't even in the state of Michigan. I was living out of state at the time, and you guys they have my email, and they never even emailed me. They have my phone number, so I wasn't notified by phone, email, or mail. So if they served it to the Elwha House, Chuck is the one who signed it, which is fraud. He has been defrauding the court since the beginning of this.
There is a proof of service in the file that was filed on November 8th, 2023, that a notice of hearing for the show cause on December 4th went out. Have you, Ms. Fort Williams, talked to your client? How would you like to enter a plea on her behalf? What plea?
No, she doesn't need to enter a plea on my behalf. I said I don't want an attorney. Why do you keep going to her? I want to speak for myself.
All right, let me say this. Ms. Dineski, you've been advised of your right to have counsel. Is that correct?
No, I have a right to assistance of counsel.
All right.
Okay.
Do you want assistance of counsel, Ms. Dineski?
She can assist. She already told me her opinion, so I appreciate that, and I'm competent to speak for myself now. But I do appreciate her very much.
So you asked for the assistance attorney, Ms. Fort Williams.
No, I didn't ask for it. She gave it to me, and I accepted her opinion. But I don't. The law does not agree that I can't ask for this to be dismissed in an arraignment, because Lufkin v. McVicker
So
says
your
that
request for dismissal is denied.
Why?
And Your Honor, I would ask.
And you have to. I'm also.
Hold on, I need to hear from Ms. Fort Williams.
It's my turn to speak. When do I get to speak?
Hold on.
Your Honor, I asked that a plea of not guilty be entered, and I'm asking that she be given personal bond. She is a resident of Detroit, Your Honor, and she's been incarcerated since the 13th. And I'm asking that she be released on her personal recognizance. Thank you.
Because I'm living locally. If I knew there was a court hearing, I would have been there.
Mr. Judge, if I can hear from you, please, as it relates to bond.
Your Honor, as it relates to bond, I did have the opportunity to speak with the petitioner prior to today's hearing. It's my understanding that there has been numerous instances of contact with the contact from respondents beginning on or around December of 2022, which I understand predates the personal protection order, this being when unwanted contact is alleged to have began, and the last instance of unwanted contact on or around February of 2025, just 5 weeks ago is what I've been informed of. I would, given both the allegations of contact and the information of continuous contact, as well as respondents' failure to appear for the prior proceeding, I believe was set for a bench trial, it does appear that there may be a concern of respondent attending future court hearings. And as such, I would argue that a GPS tether would be appropriate for both the security of the public and petitioner, as well as securing the respondent's future attendance at court proceeding.
All right.
Do I get a chance to speak on my own behalf?
I'm going to give you that chance. Ms. Dineski, are you incarcerated for any other matter?
Yeah, I'm incarcerated, falsely arrested, because I asked to talk to a supervisor when I was pulled over in River Rouge, and they beat me up and pulled me out of my U-Haul and beat me up and arrested me and put me in a dungeon for 3 days and then brought me here.
All right,
so I'm fighting those charges as well. And the thing is, this PPO, since the beginning, ma'am, I have been telling you that this needs to be dismissed. I have not had my chance to put any evidence in. You unlawfully dismissed the PPO that I had against Charles Nerswick, and then you went ahead and reissued a PPO right after you dismissed the one that I had against him, which is unlawful. You dismissed the original PPO against Charles Nerswick that I had after he admitted to trying to run me over. I'm talking now. It's my turn to talk. Let me talk.
What is your bond on the felony case? You're charged with a felony right now?
I am, unlawfully. And I'm already getting a tether, so it's a moot point.
So what is your bond on that case?
$10,000.
That
and I'm going to be asking for a bond reduction.
All right, so
I'm not even going to be getting out anytime soon anyways. But my point is that this needs to be dropped because I've never been able to show evidence. And on my
a $10,000 cash surety with tether?
Yeah, with a 1% or 10, whatever. I have to pay $1,000 to get out.
Okay, so it's 10,000, 10%?
I guess, yeah.
With tether.
With a tether. So the thing is, but my point is, I would like to speak on my own behalf about this PPO because you dismissed. You need to recuse yourself because you have violated my rights from the beginning of this case. You did not let me show evidence in my original PPO case, and you dismissed the PPO when I never had a chance to have evidence. And that man, Chuck, who kidnapped my babies from me, who has never even been found to be the biological father of these children. Lawfully. The thing is that you dismissed. You said I could have a chance to talk. Please let me state my case.
Mr. Tudge would like to speak at this time. Go ahead.
It's my turn. You said I could have it, and you keep letting them speak, and you will not let me speak. It's my turn to speak. So I'm going to say that this needs to be dismissed because you did not let me show evidence, and then you dismissed the PPO against a dangerous man who admitted to trying to run me over with his vehicle on his documents, and then you dismissed it and turned around and gave him a PPO against me when I was asking him to let me see Haley, who I raised for 5 years, and to get diapers for our babies who he had abandoned for over a month, and then he kidnapped, and then you facilitated that kidnapping. So you must recuse yourself from this case because you have violated my rights numerous times, and I've asked for a quo warranto. I have asked you to show me your Article 3 oath, and you have refused. And if you're an Article 1 judge, you cannot oversee this matter.
Ms. Dineski, your request to dismiss the matter is denied.
Why?
Mr. Tudge.
Why? What lawful reason do you have to continue this?
Mr. Tudge, what would you like?
Judge, you need to answer me. What lawful reason do you have to continue this?
1 second. Go ahead, Mr. Tudge.
Thank you, Your Honor. As it relates to other bonds, I did have the opportunity to search. I believe the case in reference would be a 22nd district court case. Presently, my records are not showing any arraignment having taken place. I did search the Michigan court case search system and did not locate any present bond or active case involving respondents. Now, I do see that there had been issued charges for assaulting, resisting, or obstructing a police officer, which would be placed at the 22nd District Court. Also,
those were dropped. They told me that they were dropped and they let me go because they wrongfully arrested me based on a false allegation. So that I have to deal with.
Trying to get information from Mr. Tudge. Let him
No,
finish.
I know, but I'm letting you know what happened in that situation. Somebody had me arrested, and then they found out that the guy gave them false information, and they originally were going to charge me with that, and then they let me go that night, and they said they were dropping the charges. So for some reason, it just never got taken out of the lien system, and I didn't know that. So I do have to deal with it, but that's not my fault. That's the 22nd District's fault.
Okay, let me hear from Mr. Tudge. He's reading from the system so that I know what it is that he sees that's in the system. And so you know what's in the system. Go ahead.
I do appreciate that. Thank you.
I would also note a case out of Washtenaw County that does appear to have also been charged with 2 offenses, misdemeanor disturbing the peace and attempt misdemeanor of assaulting, resisting, or obstructing a police officer.
That's the one that got dropped.
I have not, I'm not in possession of any adjudication on the matter.
That's the one that got dropped. I'm sorry. I thought that was the 22nd Circuit.
So I can't provide any further information. As it relates to respondents, what I would interpret as respondent's motion that Your Honor recuse yourself from this matter. I don't believe the requirements for recusal are met. There being no argued impropriety.
It's not really up to you to decide. You weren't there on the original case when she violated my rights and denied me a trial in the original PPO and did not let me put my evidence in. So because you violated my rights in that original PPO, you must recuse yourself. And I am demanding a new judge. I'm demanding a higher judge. I'm demanding the chief judge.
All right, Mr. Tudge.
I have a right to that.
Mr. Tudge.
Like maybe outside of this, you'd be a cool lady, but you violated my rights in this court, and so I have a right to a judge who has not violated my rights.
Are you asking that Ms. Dineski just be placed on tether?
Yes, Your Honor.
And I object to that. I should not have to be on a tether. I've not broken any laws. I've not harmed anybody. I'm the only one who has been harmed by this. This unlawful PPO has kept me from seeing my biological offspring for 2 years. This unlawful PPO has kept me from my babies for 2 years. They took a good mother. I was nursing my babies. I was with my babies every single day, and you guys helped a man who tried to kill me to cover up his crimes, kidnap those babies. You should be ashamed of yourself. And so because you helped kidnap my babies, I deserve a different judge. I am entitled to a different judge. You have shown misbehavior and impropriety under the canon laws of the judge's rules.
Ms. Dineski, I'm going to enter a not guilty plea on your behalf. You'll be given.
I don't consent to plea. There should not be a plea. This should be dropped.
I'm going to give you a $10,000 personal bond. You can be released on GPS tether.
Well, then I'll just add that to the criminal charges that I'll be filing against you in federal court.
Okay.
With the executive order that says that are you or are you not an administrative law judge? Yes or no? Why won't you answer my question? Are you an administrative law judge or are you a judicial judge?
I'll do the 10% on the 10,000.
Are you an administrative? Why will you not answer my questions? I have a right to ask you a question as a public servant.
She can.
Are you an administrative law judge, Regina Triplett, or are you a judicial officer?
$1,000 has been paid and she receives a tether, then.
Your Honor, I apologize for the interruption. However, when respondent was speaking, and they noticed it appeared that you were speaking, the audio did not come through.
Let me ask you this. So what day would you be able to do a trial, Mr. Tudge, on the allegations?
Your Honor, I did, when speaking with the petitioner, it's my understanding that there may be evidence that has yet to be sent to my office. I would believe a period of 3 weeks may be sufficient to receive the evidence.
Why is he allowed to? Why is a petitioner?
I'll make that a 10,000 personal, but she has to have a GPS tether on.
So why is the petitioner allowed to submit evidence, but I've not been allowed to?
Dineski, I'm gonna release you on a 10,000 personal bond, but you're
What
gonna
does that mean? I don't have money to pay
don't have
anything.
to pay any money. You just have to show up to court for your next court date. But you will be placed on GPS tether because you cannot violate.
But I wasn't personally notified up until the point when if you guys know, remember all the hearings I did show up to? Because I was notified. When I'm notified, I show up. You cannot put a tether on me when I was not personally notified.
Your Honor, we just need a date.
Can you tell me, can I ask a question? What address was that proof of service sent to? Like, where did they send that?
They're gonna release you. Okay, you're gonna get a 10,000 personal
bond. It's not about that.
I know, but
I would like to know what address did they send that information to?
You'll be able to look at the file. You'll be able to go into the system and see what address they have for you and access.
But can you just tell me, isn't that on record where it was sent to?
Mr. Dineski, you'll be able to check that yourself.
Right. But I want to know right now, because if they didn't send it to the address that I was living at, this needs to be dismissed.
Dineski, go to the records division in the basement of the city county building and you can pull all the records for the entire case. What address they served, the proof of service.
But I'm telling you, you told me it was the Elwell address. I was evicted from there in June.
Oh, I didn't give you an address. That's why you should go to the records division in the city county building in the basement.
But it should be, you should have the information in front of you.
The judge has indicated that you can check that yourself. You got to listen.
You can also give it to me right now. Why are you refusing to give it to me when you guys have it?
When you get out,
be quiet and listen.
When you get out, you can go to the city county building in the basement, but you must have tether.
But I can't get out because I have this other thing that I have to get bailed out for and I have no money.
Your Honor,
deal with that other case, however you deal with it. I've given you
okay, but I'm here and I can't get out. That's why I'm asking you what address, because I'm not going to be able to get there.
Your Honor, may I just say this? We're going around in circles. May I just request that we just need a date? That's all. Because
can I just get the discovery sent here?
Court Williams, I was just given a date 1 second ago. I was waiting. So May 27th at 9 a.m. will be your next court date. Do you have that, Mr. Tudge, Ms. Fort Williams?
Yes, Your Honor.
All right. So we'll see the parties back on May 17, 2020.
No, you said 27, right?
27. I apologize.
Okay, thank you.
At 9 a.m. Okay.
Why is it okay for my rights to be violated? I want to know. Why is it okay for you to violate my rights?
Ms. Dineski,
I want you to prove jurisdiction. Prove that you have jurisdiction over me. I'm doing a quo warranto. I'm demanding a quo warranto, and you have to prove jurisdiction over me.
You're gonna get out with tether. You'll be able to access.
It's not about that. This whole entire matter is void ab initio. So you have never proved jurisdiction over me from the beginning.
Just say something. Go ahead, Mr. Tudge. You got to get it out.
Your Honor, is the matter scheduled for a trial or a final pretrial?
Let's schedule it for a final pretrial.
So that's May 27th at 9 a.m., Ms. Dineski.
Yes.
Thank you so much, Your Honor.
You can get whatever discovery or whatever you need. Contact Ms. Abrams. And at least we'll know on that that you have everything.
So the thing is that I'm doing a jurisdictional challenge right now, and you have to prove jurisdiction before this can move forward under Michigan and federal laws.
Your Honor, she has the date. So is this concluded?
Yep.
Ms. Dineski has the date.
I'll take care and be safe. Thank you.
Thank you.
So you're not going to establish jurisdiction. Okay, one more crime.
Well, guys, we've come to the end of this proceeding. And honestly, you've seen everything. It's not even a whole lot for me to say. Ms. Dineski just went full sob sit, full tantrum, angry, threats, just everything that you can possibly imagine. She definitely did it. And unfortunately, even though she's a grown woman and she wants to represent herself, and then at certain times she's articulating herself well, but the things that she's saying is just out there, right? And the major problem she has is that she cannot stay quiet long enough to let somebody else talk so that she can truly get her point across without trying to give her point over somebody else to where it's getting mixed up and you're not even always hearing what it is that she's saying, which some, I'm sure, in the court, the attorney, the judge, the prosecutor might feel that there's no need to hear what she has to say anyway, because a lot of stuff that she said definitely isn't relevant and is way out there. But there's a lot going on with Miss Dineski. We'll keep up on this situation. We'll stay on top of this story. There's just so many things that she's done up until this point, and hopefully she gets herself together. Hopefully she gets her kids back if she can get her act together. But as of right now, she's not doing herself any justice. They were willing to give her the PR bond, but obviously she got other things that is holding that back, and she won't even be able to take advantage of that. So she just needs to get herself together, and hopefully everything will work out. But as always, guys, thank you for joining me here at Sovereign Citizens Hall of Fame. And you guys know the slogan for now: Sovereign Citizens Court is adjourned. Thank you, guys, and God bless.
Mr. Frank Michaud, who is present here on Zoom. Mr. Michaud, can you state your name for the record?
For the record, I am the beneficiary of the Frank Anthony Michaud Jr. estate. I am the authorized representative, and I appoint you, the judge, as the trustee, ma'am.
Mr. Mohammed.
Good morning, Your Honor.
Good morning. My apologies for interrupting your breakout, but I want to get some of the matters that are already on screen and ready cleared out. Mr. Sullivan and Mr. Moshu.
Ready?
Thank you. Today is the day and time set for the probable cause conference. How are we proceeding, Mr. Sullivan?
Judge, as I was saying earlier, Mr. Michaud has indicated that he'd like to represent himself. Hopefully, if it's acceptable to him, I can remain just sort of present for the proceedings in case he has any questions. My recommendation to him is that we demand all of the discovery in the case. We have paper discovery. I'm forwarding that to him, but we don't have any of the digital discovery. So we are requesting all of that. And then I'm also recommending to Mr. Michaud that we schedule the case for a preliminary exam. And I'm happy to be present for that as well.
Mr. Mohammed?
Yeah, Judge. So I don't believe we had an attorney on record, on file for this case. And that's probably why discovery wasn't sent over. Also, I believe we're missing some stuff as well, and we're in the process of getting them as well. If Mr. Sullivan's going to be the attorney moving forward, we'll send it to him. But if he's no longer going to be retained, then I don't know. I don't think it's useful to send it over to him. So if we can know who the attorney is moving forward, we'll send that discovery to that attorney.
Mr. Sullivan, are you formally making a request to withdraw from this case?
Judge, maybe my request is that we have an adjourned PCC for me to meet with Mr. Michaud and discuss this further, unless he'd like to make a decision just here and now. Perhaps one adjourned PCC and some additional time for Mr. Michaud and I to discuss this. We can come up with an arrangement where I'm at least receiving the discovery, on his behalf and trying to facilitate this for him. But I do want to respect his desires to represent himself.
And Judge, the people would have no objection to any adjournment. And if Mr. Sullivan is the attorney moving forward, please just send me an email letting me know, so that way I can make sure digital is sent to you.
Mr. Michaud, were you able to hear Mr. Sullivan just now?
Yes, ma'am. I heard everything that was said.
And was that a reasonable way to proceed at this time? I'm sorry.
Oh, no, I still stand as being the beneficiary of the estate and point you as trustee, and demand that this alleged debt, is discharged from my account, from my exemption account. As I sent over copies of my birth certificate, as well as an affidavit. I don't know if you received it, but it's been sent certified mail. And that is me standing as making this special appearance today. And with the challenge of the jurisdiction, since I have not really been fully told, or I really don't understand really the allegations or the nature and causes of this allegations on my estate.
Sir, I'll interrupt you just for a moment. In as much as you've indicated that you don't understand or have not been fully apprised of the nature of the allegations, we will adjourn this matter over for 3 weeks. That adjourned PCC date will be
December 20th at 8:45 with Judge Oakley.
the adjourned PCC date will be December 20th, 2023 at 8:45 a.m. That's in person in courtroom number 2 with Chief Judge Brian Oakley. And between now and then, Mr. Sullivan, you have the opportunity to speak with your client, bring him up to date on the status of these matters and explanation of the charges against him. And if you want to, at that time, have a conversation with Judge Oakley about how you be proceeding or not proceeding as counsel, that would be the time to do it. Is there anything else, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Sullivan?
Judge, I apologize for the inconvenience, but I am in a sentencing that morning of the 20th. I don't know if does the court have availability like later in the morning. I could make it work late morning on the 20th or in the afternoon on the 20th.
10:45.
That'd be much better. Thank you very much.
Thank you. 10:45 on December 20th. That concludes this matter. You're free to go. You have a good afternoon.
I'm not threatening you. Say one more word and that's 30 days. 30 days.